Good morning. I would like to take this opportunity to welcome all the participants to this webinar. We are quite pleased that we have a lot of people showing interest in participating in this webinar. I am with my colleagues. I will introduce them. Some of them will be speaking. I have Advocate Colin Weapon, who is a full-time member responsible for POPIA. Then we have Professor Sizwe Snail, a part-time member, and then Miss Alison Tilly, another part-time member. I'm also accompanied on this webinar by two executives, Mr. Nemasisi and Ms. Sulal. And we also have Ms. Nomza Muzondo, who is our communications person. And with those few words, I would like to welcome all of you. And to say, there's an English expression that says that a journey of 1,000 miles begins with a single step. That single step started on the 1st of December in 2016, when the 5 members of the regulator took office. And at that time, as I normally would like to remind all South Africans that at that time there was no information regulator, there was nothing. When we met for the first time at the Department of Justice in a boardroom, all that we had was the copies of the Protection of Personal Information Act, and we had to work out what kind of organization we want to build. And it was clear at that time in our minds that ours is a human rights mandate, because the right to privacy and the right of access to information are the rights that are entrenched in our constitution. And we are now 15 days left before the 1st of July 2021, which is the date on which the enforcement powers of the information regulator will come into effect. We have done a lot of things in preparation for that day. We have released a number of guidance notes and a guideline to try and assist responsible parties to comply with this complex piece of legislation. And as we prepare for the 1st of July and post 1st of July, I think all of us have to be mindful of the fact that we are all of us, we as the regulator and the South Africans, we are creating history. History in the sense that for the first time, the right to privacy as it relates to the protection of personal information, which right is very closely linked to the right to human dignity, will become a reality for the first time in our country. And also to say that we will be taking over the responsibility of regulating PAIA from the South African Human Rights Commission on the 30th of June this year. And we should always bear that in mind, because that also signifies a change in the way in which the right of access to information has been enforced in this country for the past 19 years. There were no consequences for non-compliance, but post the 30th of June 2021, there will be consequences for non-compliance with POPIA. This new journey is going to be bumpy. It's not going to be smooth. We have come up with a number of guidelines, as I said, and guidance notes. And in the implementation and application of these guidance notes that we have produced, we find that there are some unintended issues which we are coming up, or which we are realizing. So we'll have to, all of us, join hands to smoothen this bumpy road to ensure that as we move forward, it is smoothened so that we are able to all give effect to our constitutional mandate. With those few words, I'm going to hand over to Advocate Weapon, who's going to take us through his presentation on POPIA. Thereafter, Ms. Tilly will then do her presentation on PAIA. That will be followed by a Q&A. I will not come back to the podium. I'm just going to ask them to follow each other in the order that I have mentioned. With those few words, once again, thank you very much. We are really grateful for your participation this morning. Thank you very much. Advocate Weapon.
Thank you, Chair. Thank you so much for the opportunity. Chair, safe to say that I'd like to greet the chairperson of the Information Regulator, the members of the Information Regulator, all executives present, panelists, as well as participants who've actually joined the regulator during this webinar. I am going to start my presentation. It's quite a lengthy presentation, but I promise to come in at 45 minutes. Yes, so taking on from where Chairperson left, the Information Regulator is a juristic person, and it's defined in terms of Section 39. And as a juristic person, we are then deemed as well as to be a creature of statute. And what is very important is to note that the Information Regulator is an independent, is independent and only subject to the Constitution. What is very important about that specific statement, as well as section in the Act, it basically confirms the independence of the regulator. As we all know that the regulator in terms of Section 39 reports to Parliament, and what is also very important to appreciate about that is also to safeguard and guarantee the independence of the Information Regulator. What is very important is that we execute a dual mandate, and the dual mandate that we are responsible for is actually confirmed as a constitutional mandate as well in terms of Section 14, the privacy, and Section 32, promotion of access to information, and hence the two acts, POPIA, Section 14, which refers to privacy. We only cover privacy as it relates to the processing of personal information. And then promotion of access to information, which is also then regulated by legislation, particularly the promotion of access to information. What is also very important to understand and appreciate is the fact that we are 5 members, and these 5 members consist of the chairperson, 2 full-time members, Advocate Stroom and Advocate Weapon, as well as 2 part-time members, Professor Snail Kamtuse, as well as Ms. Alison Tully. Just to correct one mishap, we are accountable to the National Assembly. Parliament consists of 2 houses, which is the National Council of Provinces, as well as the National Assembly. So we, for all practical purposes, we report to the Portfolio Committee on Justice and Correctional Services. What is also very important to appreciate is that, as the chairperson said, the 5 members took office on the 1st of December, and it's been a journey of 5 years. Safe to say that there are about 5 months left of the journey before the term of the members come to an end. I'm just going to go straight to the definition section now. A data subject is defined as a person to whom personal information relates. What is very important about the data subject, in some legislation is referred to the center, because what we are purposed to do is to protect the personal information of data subjects from a POPIA perspective. Personal information, I'm not going to go into the long definition, but safe to say, consists of or is defined as information that relates to any identifiable living human being, and that identifiable living human being is also has certain personal information. Some of it would relate to his colors, sexual orientation, age, physical or mental health, and etc. Private body is also a juristic person and also who carries on trade, business, or a profession. Processing's got quite a long definition, but safe to say that processing for our intents and purposes, it consists of any information that is collected, stored, retrieved, changed, and then itself confirms the ambit of processing. It's quite involved. And then, colleagues, we are going to go over to the mandate of the information regulator. So the mandate of the information regulator in the main is derived from section 40 of POPIA. And the mandate of the information regulator in the main relates to us providing education, monitor enforcement and compliance, consult with interested parties and handle complaints, also to conduct research and report to Parliament, issue and amend or revoke codes of conduct. Codes of conduct is actually covered under section 60 to section 69 of POPIA. And what is also very important to appreciate is us facilitating cross-border cooperation, which is in the main covered by section 72 of POPIA. What is the purpose of POPIA? The purpose of POPIA in the main is to give effect to the constitutional right to privacy, as I've mentioned, only as far as it relates to the processing of personal information. As you understand and know, is that
Advocate Webpoint, I'm sorry to interrupt you. We are just seeing, we can't see your face, we see your chest. Can you kindly adjust your mic, please? In fact, we don't see your face at all now, it's gone. Yes.
Sorry,
that's all. Just leave it there. Thank you very much.
Oh, sorry for that, and sorry, Chair.
Okay, thanks.
Thank you, Chair. Yes, let me just continue there. Sorry for that. Nasir? Yes, yeah, so I was just dealing with the purpose of POPIA. So the purpose of POPIA is to give effect to the constitutional right to privacy as far as it relates to the processing of personal information. It also deals with safeguarding of personal information when processed by a responsible party, subject to justifiable limitations, as we can see and will also refer to in the 8 conditions for lawful processing of personal information. But in the main also, we're looking at a balancing right to privacy against any other right, particularly the right to access to information, because it's very important, because sometimes it's referred to the opposites of the same coin, POPIA and PAIA. So we need to balance those two rights to ensure that there's no one that trumps the other, but to actually ensure in a particular circumstance, in a certain context, the right to privacy and the right to access to information is actually balanced. The application of POPIA applies to the processing of personal information entered in a record or by a responsible party by making use of automated or non-automated means. So that would be one of the ways where POPIA applies. POPIA takes precedence over other laws that relate to processing of personal information, and that in itself provides for us with a very good position to say that POPIA, as far as it relates to protection of personal information, is considered the area to apply in those instances. implementation of POPIA. We all know that POPIA is supposed to be on the 1st July, but all responsible parties are readying themselves for. But to say that POPIA in the main and the readiness that we are referred to is actually to ensure that responsible parties ready themselves to comply with the provisions of POPIA and PIA. But that's on the one hand. On the other hand, it's also very important to understand and that the information regulator as juristic person must also comply with provisions of POPIA and PIA like any other responsible party, because we are a juristic person, and that in itself is very important. And safe to say that regulator has taken a lot of steps to actually ensure that we ready responsible parties to comply with the provisions of POPIA, and that in itself is confirmed by the type of actions that a regulator has actually put in place. Safe to say that the function of PIA, which Ms. Tully will speak to, is still located within the South African human rights, and the South African human rights will also ensure that come the 30th of June, in consultation with the regulator, ensure those funds are transferred to the information regulator in line with the MOC that we have of cooperation, as well as a project plan which we implement to ensure a smooth transfer in terms of Section 1144. What is also very important for us to appreciate is the good work that the South African human rights have done for the past 19 years or so, but also safe to say that there will be compliance requirements that responsible parties will have to adhere to, as to ensure that non-compliance consequences are not, dished out, if I can use that word. What is also very important for us to appreciate is that on the 1st of July, Section 58.2 of POPIA is supposed to become applicable to the processing of personal information referred to in Section 57. But the regulator will in due course issue a notice with regards to higher authorization, and that itself will then provide for a clear direction as to how responsible parties should proceed with regards to
Sorry,
higher authorization.
Advocates, can you please just our questions there in the chat? Your voice is moving too fast and the slides are not moving at all. I think I'm not the only one having the same problem. Yeah, so you're speaking, but the slide is moving, so we don't even know where you are or what you're talking about now. We're quite confused.
Okay, let me just direct you. I'm currently on slide 15. Can we just go to slide 15? Yes, yeah, correct. Sorry for that, apologies. So when we look at slide 15, we refer to regulations that are made by income section 1122. So these regulations, in effect, actually have been provided, and we have also provided for different dates. For instance, Regulation 5 will become applicable for the issuing of codes of conduct on the 1st of, or has become applicable on the 1st of March, and operative Regulation 4, which relates to responsibilities of information officers, have come into effect on the 1st of May 2021. And we also know that there is a guidance note that was also issued for these for the specific regulation 4. And this regulation in the main is supported by the guidance note on information officers and deputy information officers. And that specific guidance note provides a basis and also direction as to how and what is required with regards to information officers and deputy information officers. Concerning Regulation 5, we have also issued a guidance, we have also issued guidelines on the development of codes of conduct in terms of Section 41F, Roman figure 2, and that in itself provides for us a basis on which codes of conduct should be developed. Slide 16, please. On slide 16, we have the different role players. So I've mentioned that the data subject would form the center of the processing of personal information. In the main, the Act seeks to protect the rights of data subjects. Responsible parties are public or private bodies who either alone or in conjunction with others process personal information and also determine the means for the processing of personal information. What is also very important is the definition on an operator. An operator basically is considered in plain language as a service provider, either in terms of a contract or a mandate from a responsible party. And that mandate is then also enforced through a contract of some sort. And that then provides for a clear definition on an operator. An operator operates on behalf of a responsible party. A competent person in our law is considered anyone who's over the age of 18. And that competent person is also considered to be a responsible party. Is also considered to be a data subject. I'm now going to go to the 8 conditions for lawful processing. In the main, we've got 8 conditions. The first condition relates to accountability. The second is processing limitations. The third is purpose specific. The fourth is further processing limitation, as well as the sixth, which is referred to as limitation. Information quality. And the 6, openness. 7, safeguards, security safeguards, and 8, data subject participation. With regards to accountability, in the main refers to responsible parties that must ensure compliance with the conditions for lawful process. With regard to processing limitations, the Act is clear that any processing activity that is being undertaken must only be done as far as it was requested or under, and that itself also involve principles and issues of minimality, consent, and justification. And what is also very important to note is that it is required in terms of processing limitations to only process the type of information that is relevant to the activity that you are undertaking. Purpose specification. Under purpose specification, we also find that you must also, or it is required that information must only be processed for a specific purpose, and it must not then also go over and above that specific purpose, but also in the main relates to how records should be retained and also how records should be disposed of if and when the purpose for which the information was collected has been achieved. What is also very important is the issues of exemptions and also how we deal with such and exemptions in the main in terms of Section 14 would refer to what we would call the 3 grounds, which involves historical research as well as statistical purposes, which in some instances are exempted. We also then note that it's very important for us when the purpose for which the information was obtained and processed has been achieved, that we will then go into a disposal process, and it can be done under the 3D principle, which is delete, de-identify, or destroy. And that in itself should also be contained in your records management policy and your disposal processes in line with the time frames and the categories that have been allocated for such. Further processing refers to the fact that further processing can happen, but it should be in line and compatible with the original purpose for which information was acquired. What is also very important to understand and appreciate about further processing is the fact that the further processing must, if it's not compatible with the original purpose for which information was obtained, and then consent would then be required for such further processing to take place. Information quality relates to an accurate and complete set of information that must be kept on record and that is not misleading. If and when the information that is on set is incomplete or inaccurate, the data subject then reserves a right to also request to correct his or her personal information that is on record and that is being kept by a specific responsible party. Openness in the main relates to a responsible party and his or her right to maintain records, and also the fact that the notification to data subjects must be sent when such information is collected. Security safeguards relate to and is done in terms of Section 19. Section 19 in the main refers to two instances or two pillars, if I can use that word. The first pillar relates to organizational requirements. Organizational requirements is basically referred to as your policies, processes, and procedures that you need to put in place in readying yourself for the coming for the 1st of July. The second part relates to what we would call the technical requirements. Technical requirements in the main relates to your patches, Microsoft licensing, and also other requirements from a specific industry, depending on which industry you belong to, that you need to comply with, as well as your ISO standards, etc. And that in itself would then ensure that reasonable safeguards are put in place. What is also very important to appreciate is that the information regulator will release a guidance note on the meaning and interpretation of appropriate and reasonable safeguards as to provide more direction and understanding of what appropriate and reasonable safeguards is actually entails. Data subject participation. Data subject participation in the main refers to correction and deletion of inaccurate and irrelevant or outdated information that is being kept, and also the manner of access to information by a data subject. Next slide, please skip slide 21. We can go to slide 22. In terms of slide 22, I've just referred to the adequate safeguards that needs to be put in place. But what is very important to appreciate about the adequate safeguards, in case of a data breach, you as a responsible party will have to also look at the root cause for the data breach. And if the data breach is as a result of an internal compromise, that specific root cause must then be communicated to the information regulator, so that the information regulator can also, if it undertakes an investigation, come up with appropriate recommendations to ensure that the root cause is adequately mitigated. Implementation of POPIA, slide 23. What is very important to appreciate is that the information regulator has started the process issuing guidelines that now relates to codes of conduct, but also guidance notes. And what is very important to appreciate is that we have issued a guidance note, as I've already referred to, the guidance note on information officers and deputy information officers. And that in itself is a very important step to ensure that when information officers and deputy information officers are appointed, that you maybe make use of the guidance that has been provided by the information regulator. There's also this further guidance that the information regulator will provide. But what is very important about the guidance note on information officers and deputy information officers is that it provides for a basis on which a deputy information of an information officer should be appointed, as well as an information officer who will be acting, and that process is done through a process of authorization. Deputy information officers are actually appointed through a process of designation, and that in itself provides a clear basis on which deputy information officers should be appointed. It depends on the size and the complexities of the activities of a specific responsible party when considering the appointment of deputy information officers. But what is very important to appreciate is that deputy information officers must be appointed in order to ensure accessibility to of a specific responsible party. And what is also very important about the appointment of deputy information officers is the fact that the regulator does not have a specific number that they would prescribe. Safe to say that the responsible party must do its own assessment to establish and also ascertain the number of deputy information officers, if any, it would require to ensure accessibility and also to ensure compliance with the requirements of the provisions of POPIA and PIA. What is also very important to appreciate is that the information regulator has issued a guidance note on authorization in Section 57 and Section 58 of POPIA, and the regulator will in due course provide further direction with regards to PIA authorization, and you can expect within the next two weeks at most some form of direction with regards to PIA authorization. Safe to say that there was a notice published in the Government Gazette, and there might be a possible amendment to that specific notice. What is also very important to appreciate is that the regulator is in the process of finalizing a guidance note on exemptions for conditions as contained in Section 36, 37, and 38 of POPIA. That specific guidance note will within the next 2 weeks be made available on our website or published on our website. The regulator also intends to produce a guidance note on direct marketing in terms of Section 69. We had multiple discussions with DIMASA, direct marketing in South Africa. In this regard, it was also then communicated to DIMASA that such a guidance note will be developed in due course, and it will also then be published on our website. What is also very important to appreciate, as I've mentioned, there will be a guidance note on the meaning and the interpretation of appropriate and reasonable technical and organizational security measures, and that guidance note will also be made available in due course. The regulator is also in the process of developing its template to report the data breaches, and that template will also be made available as soon as it is approved by the information regulator. Slide 27. With regards to slide 27, we're looking at the information officers and deputy information officers in terms of Section 55 and Section 56. Safe to say that the regulator has also developed a specific guidance note, and the guidance that the information regulator provides is quite of a general nature. What is also very important to appreciate with regards to the appointment of deputy information officers is that deputy information officers must in fact be employees of that specific responsible parties. And what is also very important for us to appreciate is that deputy information officers, by their nature, must have a reasonable appreciation and comprehension of the business activities of that specific responsible party, which they would be processing personal information for, and also their roles and duties as would be provided in terms of the designation of responsibilities by that specific responsible party. And what is also very important for us to appreciate is that in the main, the information officers must take up their duties only after they have been appointed by the information regulator. And that in itself is contained in section 55(2) of POPIA. And it provides for the fact that information officers must be registered. There is a portal that the information regulator has made available. We also understand and appreciate the technical glitches and the frustration that responsible parties are currently experiencing when registering, especially those who want to use the same identity number for multiple registrations. The system is in the process of being enhanced. As soon as we have enhanced the system, one person, a natural person, will be able to use one identity number to register for multiple juristic persons. And we also do apologize for the frustration. And at times the app might not be available, or there might be technical glitches. But we are working on it to ensure that the portal becomes more accessible. But it's also considered to be teething problems as we proceed. Slide 31, trans-border information. The information regulator views the issue of trans-border or cross-border transfer or trans-border in some instances as being used interchangeably. What is very important to appreciate is that Section 72 provides for a two-step approach. First would be that there must be binding corporate rules in place before personal information of the subjects are transferred to another jurisdiction. The second one relates to what the regulator is busy considering, which refers to adequacy assessments. Adequacy assessments relates in the main to the fact that jurisdictions which personal information of data subjects will be transferred to, that specific jurisdiction will then be assessed to ensure that we determine the adequacy of their legislation of that specific jurisdiction against POPIA to see if they have same or similar provisions in place to protect the personal information of data subjects. And that in itself provides a basis for us to actually ensure that the jurisdictions that personal information of data subjects are transferred to have and complies with the adequacy standard or determination that we will put in place as the information regulator. And then what is also very important, which I've also referred to, is the fact that a guidance note on cross-border information will also be considered and be finalized in due course. But safe to say that trans-border information in the main relates to the transfer of data subjects' personal information to foreign countries, foreign jurisdictions. But what is also very important here, and the regulator appreciates the dynamics. For instance, our social media platforms that we use, such as WhatsApp and Facebook, usually have the personal information of data subjects, and that personal information is stored in foreign jurisdictions already. The information regulator also appreciate, this borderless concept of information flows, and that in itself becomes very important for the information regulator to continuously engage responsible parties. What is also very important to note is that a data breach that has occurred a few years ago, which is referred to as the Cambridge Data Analytica, refers to a compromise of in excess of 495,000 users of Facebook, specifically South African users of Facebook, And that in itself have triggered the information regulator to consider ways and means to engage and address data breaches which occurs outside of the borders of South Africa. As you would know, that the information regulator does not have powers to regulate personal information outside of the borders of South Africa. In terms of Section 39, the Act is only applicable within the boundaries and South African jurisdiction. We, unlike the GDPR, don't have extraterritorial application, and that in itself provides clear direction that we can only regulate and enforce POPIA within the borders of South Africa. With regards to the enforcement powers of the information regulator, it's very important to state at this stage that enforcement notices can be issued in terms of Section 73 to Section 99. Those enforcement notices that we refer to could be issued maybe with regards to a data breach that has occurred in terms of Section 22. And that specific data breach, if it happens, would then trigger, in some instances, an enforcement notice, and that enforcement notice will then clearly stipulate what specific conditions that needs to be complied with, and failure to comply, or if there's non-compliance, it can then attract, as we see later in the presentation, fines and penalties, and those fines and penalties set out into Section 100 and 1. With regards to complaints, the regulator has in the past proactively accepted complaints, and we've done this mainly just to assess, the type of complaints that will be put forward. Also, the number of complaints that exist, but safe to say that we didn't have enforcement powers.
Advocate Weapon, I'm sorry, Advocate Weapon,
Yes.
I'm coming to you again. We've just seen your chest again. This is live on Facebook.
Okay.
So, and secondly, can you please round up, because we want to give as much time as possible to Q&A. If you can just
Yes,
summarize, please. Thank you. Sorry for interrupting you.
No problem, Chair. Understood. What is also very important is the fact that we need to appreciate that compliance notices will be issued by the information regulator. And what is also very important to understand, slide 36, please, for me just to round up, investigation powers of the information regulator. The information regulator can issue summons and enforce the appearance of persons before the regulator, can administer an oath. There's also the search and seizure powers that the information regulator has. And what is also very important to appreciate is that the information regulator is in the process of establishing its enforcement committee, and the enforcement committee in the main will be chaired by a retired judge. And the regulator has taken that decision, and that decision is also then one that will then allow for the enforcement committee to be constituted. What is also very important to appreciate is that the chairperson, who will be a retired judge, will be supported by different members, and those members will then be appointed depending on the type of skills that will be required for a specific enforcement meeting. The information regulator intends to put up an advert so that we can invite members of the information of the enforcement committee. Lastly, just to look at the functions of the enforcement committee. The enforcement committee in the main makes recommendations to the information regulator, which is the members, and the members can either accept the recommendation or reject the recommendation, or amend the specific recommendation. In instances where the information regulator has made decision, based on the recommendation of the Enforcement Committee, the decision is deemed to be final. And if a responsible party or data subject is not happy with the decision of the information regulator, that specific decision can be taken on review at the High Court, and that would be one of the remedies that are available. Just to round up, Section 107 provides for a penalty of up to 10 million or imprisonment of up to 10 years or both for non-compliance with the requirements or the provisions of POPIA. Chair, in the interest of time, I'm going to stop there and also allow for questions at the stage later on, Chair. Thank you.
Thank you, Advocate Weapon. Can Ms. Tilly please follow immediately? Thank you.
Thank you, Chair. Yes, good morning, everybody. I will be sharing the screen from my side. I'm Alison Tilly. I'm a part-time member of the Regulator, and I've been around for about 5 months. Let me start us off with the section of the Constitution that is relevant to us. The section is Section 32 in relation to the Promotion of Access to Information Act. I know everybody's heard a lot about POPI. There's a lot of focus on POPI, but the regulator is in fact has 2 acts and 2 rights effectively that we're responsible for. The one is, as Advocate Weapon has said, the right to privacy, and specifically the right to informational privacy. But the second right that we look at is the right of access to information. It's not, when we say access to information, it's probably more helpful to think of it as the right of access to records. So this is the right and the act that allows you to ask for records which are held either by the state, and also records held by people who are not part of the state, so private bodies and private people. In that instance, you can only ask for records that are required for the exercise or protection of the rights of the requester or another relevant person. But it applies both in the public and private sector. That's the main point that I'm making. Why do we have this piece of legislation? The idea is that we're fostering a culture of transparency and accountability in public and private bodies, and working towards the constitutional goal of an open and participatory democracy. The history of the country is very much one of secrecy on really every side of every divide. Both the apartheid government and revolutionary movements adopted secrecy, but for very different reasons, obviously. But there is a deliberate decision in the Constitution to make the transition to transparency and accountability. I'm giving a bit of background here just because it may help understand how POPIA and PIA work together, which they do. PIA was originally introduced under the title of the Open Democracy Bill, and it dealt with a range of issues, including open meetings, whistleblowing, and privacy and access to information. Now, the Constitution required that legislation be passed to give effect to Section 32 of the Constitution, and that legislation is PIA. PIA has been in operation for quite some time, so since 2001, and the legislation sets out a way of requesting records. So what kind of records you can ask for, what records you can't ask for, the forms, what the process is in terms of the way you do it. So the idea is that you're going to have this piece of legislation promoting transparency, accountability, and effective governance. In encouraging openness, one of the key things POPIA does is try to establish mechanisms which give effect to the right of access quickly, cheaply, and easily. Now, for anybody on this call who's done an access to information request, you will know that your experience, well, I would guess that your experience is going to be exactly the opposite. It wasn't quick, it wasn't easy. And part of that is because there is no enforcement mechanism in place other than the courts. And even at one point, only the High Court. So you couldn't even go to a magistrate's court. You can go to a magistrate's court now, but I think the reputation of POPIA that now precedes it is that it is really ineffective in terms of giving access to the right to information. And really that's where the regulator then comes along and plays a role, which is the regulator itself is a mechanism to give effect to the right of access to information. So we will be in a position where once you've made your request and lodged an appeal, if that's necessary for a record, and you're not getting that record from that person, you can then come to the regulator, and we then have a number of powers in order to deal with that. There's obviously a strong emphasis on mediation, and it's new, trying to explain to everybody what records should and shouldn't be made available. But in the event that there's some difficulty, we can request the records directly from the party that holds the records. And then we also have order powers in relation to the release of records. So that is something that is within our mandate. Our decisions are obviously not final. We can be taken on review, and so there is that. People can also approach a court directly. You don't have to come to the regulator for assistance if for some reason that doesn't seem like a good idea. So we have this idea that there's going to be this quick, cheap, easy mechanism to establish the right to access to records in a way that's meaningful. Just to come back to some things that Advocate Weapon said about information officers, may be helpful in thinking about an information officer. It's to remember that the genesis of the idea of an information officer was actually in POPIA. And the idea of an information officer is the person who's really going to be responsible for access to information in whether it's a private body or a public body, but more importantly, somebody who is going to act as a steward for access to information and for transparency in that organization. The idea that you're looking at somebody senior who's really going to try and lead the organization in trying to make this transition from a history of secrecy and into the new constitutional order involving transparency and openness. What we have now, of course, is information officers that are going to deal with both. So just to come back to a slide that Advocate Weapon was talking about, both POPIA and POPI need you to appoint an information officer. And as he was saying, we've got the portal for the registration of information officers. I mean, our difficulty with that portal, I'm sure you've some of you have mentioned in the chat the difficulty that you're having in terms of that. We are, I'm afraid, keenly aware of those difficulties, and we are asking the tech support people to work on those issues. But it's important. It is important that you have an information officer and deputy information officers in order to lead the kind of change that you're really looking to see in organizations in kind of aligning their practice with the Constitution. Just as a last slide, this question of information officers, deputy information officers, again, it's not something that a small organization would need at all, so it may not be relevant for you. But for bigger organizations, having deputy information officers who can then lead on that from a particular unit or a particular subsidiary, or whatever the particular shape is of the organization. There is one thing I would I would like to add. I've noticed in the question somebody talking about a POPIA manual. There's really the manual that we're talking about when we talk about these manuals is a PIA manual in terms of section 14 of PIA. That is a manual on the functions of an index of records held by a public body. That's the title of that section in the Act. And while it does deal to some extent with how you're dealing with data processing, it also deals with access to information. So just to put that out there, that the PIA manual is really the one to be focusing on. All right, I'm going to stop share there. Thank you very much for your attention, and I hope we will be able to answer your questions. Yes, I didn't put my slides on PowerPoint mode because I'm never entirely sure that I'm going to quite manage that for some reason. But oh yes, and we will certainly be able to share the slides with you. Good. All right. Shall we move on to questions? And perhaps for that I can hand over to Prof. Snell.
Professor Snail? Professor Snail, can you please proceed with the Q&A? Yeah, we seem to have a bit of a problem. Nomzamo, can you please do the Q&A for us, please? In the meantime.
Okay, thank you very much, Chair. I'll just, maybe before I go into the chat group, I can perhaps just read out a few questions which we received through Facebook, because as you had mentioned, yes, we are live on Facebook. So I'll just read out a few from there.
Nomzamo, I don't know if it's on my side, but your volume is quite low. I don't know. Can you deal with that, please?
Okay, am I audible now?
It can be better. It appears Professor Snail is here. Are you here? Are you, Professor Snail? Okay, continue.
Am I audible now, Chair?
Good, yes, you're good.
Okay, sorry about that. Let me try this again. I was just saying, Chair, that we have a few questions that have come through our Facebook page as people are watching live. So I'm just going to first read out those questions that we've received from our Facebook page, and then I'll allow the panel members to respond. And then thereafter, I will read a segment from the chat, and then we'll allow responses as well. So the first question that we received, which is from Darlene from Demon, she asks, what is the portal's technical problems, or when are they going to be sorted out, please? And then she further asks, what happens when a person is appointed as an information officer to more than one entity? Because the portal does not allow for this registration. It rejects the application if the ID has been used in a previous application. And then the other says the same applies with the deputy information officer. The second question is about our email boxes, which are full and emails are bouncing back. So where can application forms, manual application forms be sent? And lastly, should we courier them? What is the address that we can courier the manual application for information officers? I'm just going to stop there for now, Chair, and then I will come back with questions that are in the chat room. Thank you.
Ms.
I'll
Zondi,
take the question
I'm
on.
also back. The connection had a little bit of an issue. I think once the people have answered the questions, I'll be able to continue with the chair. Thank you.
Thank you, Prof. Snail. I'll take the question on the portal. The portal, all of the issues relating to the portal are being addressed by the IT team. We're fully aware of the inability of the system to deal with multiple registrations, and that's one of the fixes that's being deployed. So that will be addressed, I think, in the next few weeks at the very latest. Thank you.
Professor Snail, please take over.
Thank you, Chair. Right. So we now have the questions and answers from the Q&A box. I'm just opening them up here. The first question here we have from Rona Becker. He says, will the information regulator, as the South African Human Rights Commission did in the past, publish a template of the required POPIA manual? And when should we, with whom should we lodge our POPIA manuals with? South African Human Rights Commission, or should we wait for the 1st of July to lodge our manuals with the information regular as per amended POPIA? Can I have someone from the panel be willing to take that question?
Mr. Nemasisi.
Thank you, Chair. Prof, I can take that as well. The regulator has developed the template on POPIA manual as the POPIA has been amended. That template will be publicized in our website. But maybe now that I've got platform chair and program director, I may as well just mention that the issue of the submission of POPIA manual, after the 30th of June, the requirement of submission of POPIA manual will not exist anymore. You are not required to submit POPIA manual to the information regulator. However, you are supposed to have those POPIA manual in your website and already available at your head office upon request as well. When people request that, you can give them. But you do not have to submit a copy as in the past where you used to submit to the South African Human Rights Commission. You do not have to submit it to the information regulator. Thank you.
Right. Then we have another question here from AC Khan. Thank you for the opportunity to ask this question, I assume. Is there a basic POPIA manual template available for small NPOs doing charity welfare work? Service providers are charging way too much for NPOs, and the NPO stores personal information of beneficiaries and recipients of social relief. I think that one I'll answer myself. Being an attorney, I think there is unfortunately this practice out there of now wanting to milk the POPIA compliance issue. You know, people must be very wary of fly-by-nights, people who purport to be experts, people who pass themselves to be experts, people who claim to give certifications regarding POPIA, and charging people a whole lot of exorbitant amounts of money. That, however, does not mean that you must not be compliant. So unfortunately, compliance, if it means having to go consult a legal practitioner or privacy practitioner to assist you with those type of things, you know, then it is always good to spend a bit of money from the budget. But the Office of the Regulator is always open to assist any responsible party or data subject with any specific query that they may have. Right, then we have Henk van der Walt. Apologies for that. Right, then we have the next question here coming from Mike Burns. What is also important for the information regulator to know is that to be appointed in the gambling industry requires licensing and through background credit checks, including credit checks, criminal and SARS, all of which can be collected from the DS with their consent. I see the chairperson's hand is up. Chair, would you like to answer that?
No, I was not answering that. I was just wanting Ms. Sulal's response on the portal. There are a number of people who are asking a question about that if you have used your ID once, you can't use it again. If she can just address that question. And secondly, just following on what you said, Professor, we have received queries about companies charging people a lot of money to register themselves as information officers on the portal. We are just, I mean, if a body has money to pay a consultant for that, well and good, but we just want to advise that registering your private body or your public body on the portal is something that you can do yourself. You don't have to pay anybody anything. I just wanted to say that upfront. But Ms. Sulal, please, at an appropriate time, answer that question of IDs. Thank you.
I think I'll let Ms. Sulal answer that now, Chairperson, so that it closes the whole issue. Ms. Sulal, over to you, please.
Thanks, Chair. Thanks, Prof. Snell. This is being addressed by our IT team, where there are multiple registrations that are trying to be registered with one information officer for more than one entity, and in some instances more than one deputy information officer for more than one entity. So this is part of the phase 2 development, and it is being dealt with by Justice. Thanks.
Right. I see here there's further questions from the Facebook panel here as well. It says, how would trustees of a fund be appointed as information officers as if they are employed by the fund? Someone answer that. I think Mr. Namasisi would be appropriate.
Thanks, Prof. The requirement for the not necessarily appointment, because an information officer is by default the head of that institution. If, for example, you've got a fund which might have a principal officer, that principal officer is the one who is supposed to be registered with the regulator as an information officer. However, for a private entities or private bodies or juristic person, if I may be specific, those can actually authorize somebody else as an information officer, but you can only authorize an employee of that company. The regulator recommend that when you authorize somebody, just to be somebody of seniority who can assist you in taking accountability and making sure that the organization comply with both POPIA and PAIA. So by default, the principal officer of a fund will be the information officer, but that principal officer can actually authorize somebody else. If you look at the guidance note on registration of information officer, we do have a template of an authorization that you can use to authorize somebody else, but that can only be done by a juristic person in terms of the act. Thank you.
Thank you, Mr. Namasisi. Like I said, I'm going to be taking both questions from Facebook and the Q&A. Another Facebook question says here, what happens if the portal is only fixed after the 1st of July 2021? Is there going to be an extension for the registration of information office? May I ask Ms. Tilly to answer that one? Or Mr. Namasisi, will you answer that? Thank you. Your camera is on.
I can try and answer it. If you look at the legislation, there's no specific deadlines set for the registration of information officer. If you look at section 55 and even in our guidance note, we did not specify the deadline. Obviously, everyone wants to ensure that they're compliant before the 1st of July. But because there's technical glitches, the regulator would definitely not take any actions if people were unable to register before the 31st of July. But there is no specific deadlines for the registration of information officer. Although once the system is set up, we'll expect people to start registering their information officers.
Right. Then we have a question here by Anonymous. Thank you for this initiative. It is very important. I'm from the private medical sector. We have been advised that the information regulator will be issuing a code of conduct for the private medical sector. Could you please advise if this is still happening, and if so, when can we expect it to be published, as it may impact our POPIA arrangements? Is there any panel member who would like to take that one?
I think Advocate Weapon should deal with this question because he has been dealing with the matter.
All right. Thank you, Chairperson.
Weapon, thanks.
Advocate Weapon.
Thank you, Prof. Can you just repeat the question? I missed parts of it.
Okay, now I'll repeat it for you. The essence of the question is, we have been advised that the information regulator was issuing a code of conduct for the private medical sector. Could you please advise if this is happening? And if so, when can we expect it to be published, as it may impact our POPIA arrangements? It's from Anonymous.
Prof, thank you so much. I hope I'm visible. Yes. Yeah, so what happened, and just to give some background, thank you, Chair, for the floor, is that in terms of section 112C, we were supposed to look at a regulation. Because of our consultation, if you remember, Prof, we didn't get sufficient input. Hence, the regulator then decided to go and look at section 32.6, which refers us to section 1B and 1F. And 1B and 1F in the main look at medical schemes as well as pension funds. And what we've then decided as the information regulator was to go out and invite quotations from experts, those specific cases and cases, so that we could provide rules. And it is one instance in which we thought we'll deal with the specific matter, because it requires some expert and specialist contribution in order for us to have prescribed rules that reflect industry-specific knowledge and detail. What the chairperson has also and the members have decided was for us to have a health conference. But this conference that we are planning is still in progress, but we need to also then look at what are the needs and requirements of the health sector at large, because of the size and the complexities and the technicalities of the specific sector. It's quite a unique sector. It's also The same with telecommunications. So we are looking at a specific health conference, but it should then be at a later stage and date, still to be considered and announced by the information regulator. Thank you, Prof.
Thank you, Advocate Whitman. The following question here comes from AH. If we request credit reports from credit bureaus, do we also need to apply for prior authorization, or only the credit bureaus who create the report? It's a little bit unfortunate that we don't know in which industry you are, but I think I'll answer that one, to say, obviously, whenever you request for any credit check of anyone, I mean, that is special personal information. You will have to get the consent from the data subject. And this consent should not be fused with prior authorization, which actually deals with further processing of certain unique identifiers. I don't want to go into it too much in detail. Let me then go to the next question. Good morning. This question is from Jean-Marie. Will the information regulator be making a POPIA manual template which incorporates POPIA amendments to POPIA? Secondly, should the contact details in the POPIA manual change from the South African human rights to the information regulator? And lastly, what will the email address be for POPIA submission? May I request Mr. Nemasisi to take the floor on this one? Thank you.
Thank you so much, Prof. The issue of the template of POPIA manual, I've already indicated that the regulator has already developed. It's in the process of final approval. That template will be published. What we do as a regulator, we realize that there are people out there, consultants, who are actually milking out the public with regard to the development of POPIA manual. So the template that we have, it's user-friendly. It will enable the public to be able to populate the information that is required into the POPIA manual template, and they will have their own POPIA manual. So that will be published as soon as possible. The issue of submission of the manual to the regulator, as I indicated, there is no requirement after the 30th of June when the amendment of POPIA comes into operation for the submission of POPIA manual, unless the regulator has requested a copy of that manual as part of its compliance requirement. But without us requesting for the copy, you do not have to submit a copy to the regulator. Thank you.
Thank you, Mr. Nemesis. Ms. Tilly, over to you.
Thank you. I just wanted to chip in there. There are a set of exemptions from having to develop a POPIA manual, and these exemptions mostly apply to smaller organizations. So many people on the call may think that they are required to do a POPI manual, which you're not. There's no such thing. Or they may think that they need to do a POPIA manual, although they are a small organization. I don't have at my fingertips exactly the exemptions, but if you are an SMME, there is no requirement that you have a POPIA manual. That has been because there's been an exemption in place, which is the exemption is done by the Minister of Justice. We've gone back to the Minister of Justice and said, look, we appreciate that this is new and not everybody's going to be on top of this, although it has been in place for a long time. So there'll be at least another 6 months for people to get the POPIA manuals in order, because the operation of that is going to be suspended for that period of time. So I really would, if anybody's telling you that you have to have a POPIA manual and you have to pay the money, and you're a small organization, I really would check first, because I would just be cautious about that, because that very probably isn't the case. Thanks.
Thank you very much. Thank you for that, Ms. Tilly. Some important input there, with regards to small organizations, as well as their obligations to file POPIA manuals. Once again, please, we'd like to stress, there are a lot of people out there who are passing themselves off as experts, and who are forcing people to take on their products, please take proper advice from proper privacy practitioners or legal advice. Now, we have another question here from the FTI Zoom administrator. To what extent does personal information relate to a juristic person? AKA, does a juristic person have personal information? I'm not talking about the process of personal information. I think I'm going to answer that one, not to belabor time. The POPIA creates two categories of personal information. The one category is of an identifiable living person. You go into section 1 of the definition of personal information. An identifiable living person or a existing identifiable juristic person. So a juristic person, in terms of our legislation, can also be a data subject and can be a subject matter of personal information. We've had this question on numerous occasions, and I recall we have taken the position that a guidance note will have to come out there just to clarify on the issue of juristic persons and their personal information. Now, I don't want to repeat certain questions from certain people, so please don't feel like I'm skipping your questions if I'm not repeating. There's a question here from Michael Dolphin. Is the information officer an employee? And no, we've already had this one. Sorry, Michael. Then there's one here that says, from Rona Becker, okay. Should prior authorization applications be submitted where an entity is unsure where the processing of a unique identifier or the type of unique identifier falls within the ambit of prior authorization? With all applications that have been submitted thus far, will the information regulator be able to provide examples of what types of processing activities may require prior authorization? Can I give this question over to Ms. Solal or to Mr. Nemasisi, one of the two?
I can try to answer it. The prior authorization, the regulator issued a guidance note which is available on our website as to how people they can interpret the prior authorization, what processing are subject to prior authorization. Let me give you one example. It's going to be difficult for the regulator to give an example on processing of all the responsible parties that we have in the country because they process different personal information and it may not be easy. But let me give you a practical example of the credit bureau. The credit bureau industry, they receive the process information for credit reporting, and that processing is subject to prior authorization. So any credit bureau entity that processes personal information for credit reporting, for them to continue processing that personal information, they need to obtain a prior authorization from the regulator. That's for credit reporting. The last example that I can give, it's when you, for example, as a regulator, they want to employ an employee and they want to do a criminal record check. And they appoint a third-party company to assist the regulator to conduct that criminal record check. That private company or third-party company that do the criminal record check for the regulator supposed to obtain a prior authorization from the regulator for them to be able to process their information for purpose of criminal record search. So those are the two examples that I can give. It might be difficult to give a practical example related to your unique processing of personal information, as we may not know, or as because different companies process different information. But the short answer is that go to our website, look at the guidance note on processing of personal information. You'll be able to see which processing of personal information is subject to prior authorization. And that's available in our website. Thank you.
Thank you, Mr. Nemasisi, for the succinct answer on that one. Right, here's a question by Michael Dorfin. Is the information officer of the holding company automatically the information officer of the wholly owned subsidiary? And how do we ensure that the registration is easy given a large number of subsidiary companies? And I want to link that with Ilana van den Berg's question, where Ilana asks, is the appointment of the Deputy Information Officer voluntary or compulsory? From the panel, can I have someone who can take that one?
Thank you, Prof.
Thank you, Advocate Wimber.
Yes, Prof. So, yeah, let's just go. We have this issue about subsidiaries and also the group. Basically, what is very important for us to appreciate is the fact that if a subsidiary is a separately legally recognized entity in terms of its incorporation and also its registration as a company, that specific company, in terms of our legislation, would require an information officer. It would be very difficult, I think, if there's a group and there are subsidiaries and there's only one information officer responsible for instance, for 10 other different legal entities. Might be, to a certain extent, be some type of a complication. What is also then very important to appreciate with regards to DIO's, Deputy Information Officers, is the fact that the Act refers to if any. So if any, in our interpretation of, if I recall correctly, places a discretion on the specific juristic person, that company, to do its own assessment to see if it would require a DIO. Maybe if I use an example of a company that consists of 3 people or 4 people, 4 persons, and they have minimal personal information that they process, it might not be deemed necessary to have a DIO. But if you look at a company with 50,000 employees who have voluminous processing of personal information, that in my understanding would require a number of DIOs or responsible party, DIOs, Deputy Information Officers. And then the if any would then apply to the extent that that specific company might have to appoint a number of Deputy Information Officers in order to make it accessible to data subjects and the public at large. Thank you, Prof.
Thank you, Advocate. The next question actually has been asked by several attendees. So I think I'm going to summarize this question, and I'm going to direct the question at our chairperson. Are there any requests for extension of the grace period? And what is the position of the information regulator regarding any possible extension of the grace period? Like I said, this question has been asked by several people. I've summarized. Chairperson?
Thank you very much, Professor. We have received, I'm aware of 2 requests that we received for an extension, and the answer is no, there isn't going to be any extension. On the 1st of July, the enforcement powers are coming into operation. What we have done, though, and I have to mention, you'd recall that in terms of, I think it's section 1142, if I'm not mistaken, of POPIA, we can, the information regulator should gazette or issue a notice in the gazette on when the prior authorization sections, section 58 and 57, will come into effect. We had gazetted that those sections will come into effect. In fact, they are into effect to say any applications for prior or anyone who processes information that requires prior authorization must ensure that they obtain that information, they obtain the authorization by the 1st of July. We had gazetted that date, which meant that by the 1st of July, if you had not obtained prior authorization from the regulator and you are processing certain types of information mentioned in section 57 and 58, you had to stop processing your personal information. We have decided to amend the coming into effect of that section to the 1st of February, which means that everyone who requires prior authorization from the regulator, you'll have up to the 1st of February next year to ensure that before that date you submit your application, and we will also have up to the 1st of July to ensure that we deal with all the applications that we have received. So that's the only amendment that we have made. Otherwise, the enforcement powers are coming into effect on the 1st of July. Thank you very much.
Thank you very much, Chairperson, Advocate Lakula. There are a lot of questions here regarding the portal. I'm going to try and put these two questions together as one question, and one of the panelists should just prepare himself for this question. There seems to be issues regarding the online portal. Number one, people are unable to register because the system is down. Number two, there are issues pertaining to the individual's ID numbers. Whether it's an ID number that has already been registered cannot be registered again. Can this be rectified? And going further, it says, at what point will the IO portal be fully functional? The reason being that a group of legal entities have been unable to register their various IOs, and this is hampering the registration process. I also see here Anonymous follows up and asks if the registrations can be done physically. I know we've had a similar question before. Is there anyone who would like to answer that specific question regarding the portal?
Yes, Prof.
Thank you, Advocate.
Thank you, Prof. Can I switch my camera off, Prof, just for better call quality?
Yes,
Prof,
please.
The main issue with the portal, there are glitches. Sometimes if you do want to register, then you get some type of notice, and also some people cannot complete their registrations. But what is very important for us to appreciate is that the regulator is aware of the glitches, as I've stated in my presentation. But what is also very important, and I've highlighted this in the presentation, is the fact that we know that the person with one ID cannot register for multiple entities, as Ms. Sulal also referred to. And in phase 2 of the enhancement of the portal, these glitches and these technicalities will be addressed and resolved. With regards to the specific date, we don't have the specific date on which the portal issues will be resolved, but we intend to resolve it as soon as possible. Preferably before the 1st of July 2021. But what is also very important is to note what Mr. Masisi said, that because of the fact that the regulators are aware of the glitches and the frustration that the responsible parties have to register their information officers and DIOs, we will not penalize responsible parties if they are not registered come the 1st of July 2021. Thank you, Prof.
Thank you.
Prof, can I come in as well? I think
By all means, Chairperson.
We have to be completely open about the challenges that we are encountering. You would recall that, and this was brought up, we're still using the systems and in some instances the policies of the Department of Justice, just because of budgetary constraints until such time we are able to build our own systems, and the conversation in that regard have begun. So the system that we are using is the Department of Justice. They built it for us, and we are very appreciative of that. But it is encountering all the problems that you have all highlighted. What I have to also inform the participants is that we are looking at a plan B on how we can deal with these challenges. And a plan B, which is what the other part of the question is dealing with, is that we are going to look into having a manual registrations, so that when the system is down, we can then have warm bodies that will be able to capture the application forms. I thought I should say this. Thank you.
Thank you very much, Chairperson. And I hope the additional clarity that Chairperson has provided will then be accordingly. I have a question here from the South African Institute of Chartered Accountants. They're from Juanita Steenkamp. We have received numerous questions on how registration of information officers can be done if the system is experiencing technical issues. So we have a similar question to that. When doing a manual registration, we received the message that we should do so online. I think Chairperson and Advocate Weapon have addressed that one. Oh, interestingly, I see here there's a question from Mr. Mutlamunyane. Nice to see you again. Yes, there will be a recording of this that will be made available, and as said, we are live streaming as well. Let me just go over to the Facebook questions and not just focus on the questions on here. We have a question from Caswell Galileo. Do we have offices of the information regulator in districts or provinces that we can visit? And then maybe just to add on to that, if so, where are they, or what are the plans of the regulator? As it stands, maybe I can answer that one. The information regulator has a central office, and as we know, there are a lot of budget constraints currently going through all government departments as well as Chapter 9s. The information regulator has thought about having provincial provinces, but that is something that will need to be explored together with other possible Chapter 9 institutions that maybe can assist in receiving complaints or the like. So I hope that answers that question. Let me see. There's another question here on the Facebook. Please advise on the exemptions of compiling a POPIA manual. Okay, we've had Ms. Tilly speak to that one already. Okay, but specifically, hold on, Ms. Tilly, don't go away. Also, when the industries list will be updated in order to better determine which companies really require to do so. Over to you, Ms. Tilly.
Thanks, Prof. Snell. So just to say that I will make sure that this is up on our website if it's not there already, but let me give you the long version, which is it's in a government gazette. The government gazette number is 39504. It was issued on the 11th of December 2015, and there has been an extension of that, but the substance remains the same. So you're exempt if you have 50 employees or less, or you have a total turnover that is less than a certain amount, which is mentioned in the schedule. So if you are, the intention is to say that if you're small in terms of numbers or you're small in terms of turnover, that you should then be exempt. The exemption would be if you're in the agriculture sector, 6 million, mining and quarrying 22.5 million, manufacturing 30 million. electricity, gas and water 30 million, construction 15 million, retail and motor trade and repair services 45 million, wholesale trade, commercial agents and allied services 75 million, catering, accommodation and other trade 15 million, transport, storage and communications 30 million, finance and business services 30 million, and community special and personal services 15 million. So it really is, it's quite extensive in terms of the exemptions from compiling a manual in terms of the Promotion of Access to Information Act. This obviously all relates to private bodies. It has nothing to do with public bodies. They are required to produce a manual irrespective of their size or their budget. But I'll make sure we have it up on our website just for easy reference. Thanks, Prof.
Thank you. Thank you, Ms. Tilly. Here's a question from Chanel Frankel. Thank you for hosting this informative webinar. May you please provide clarity on compliance regarding enforcement after the 1st of July? I think Chairperson Advocate Takula has already answered that there will be full enforcement after the 1st of July. Whether the information officer must be someone within the organization or an external party. And then you draw the analogy here, for instance, where you have the managing agent vis-a-vis the body corporate, who in actual fact here would be the information officer. Maybe I'll take that one and I'll just say the de facto information officer would be the, should I say, the chairperson of that body corporate. So they would be the information officer. Now, there's also the second link to that one to say, can this function be outsourced? And I'd like to hear what my colleagues have to say on that one. Ms. Salah?
Sorry, Prof, could you just please repeat that?
Yes. You know, the first question was, in a body corporate and, you know, a managing agent situation, who or what would be the information officer? So, you know, I've already said that, look, the de facto responsible party would be the body corporate with, you know, its owners there. It would be the de facto responsible party. But in terms of the information officer now, the question here is, would one be able to outsource this? In other words, would a managing agent, for instance, be able to register itself as a chief information officer of the body corporate?
I'm going to pass this one to Mr. Nemasisi. I'm not entirely certain, because I know that in the case of a private body,
Right.
you know, with relating to a partnership, it could be someone authorized by the partner, but I'm not entirely sure with the body corporate, I must admit.
Mr. Nemasisi, can we pick your brain on this one?
Yes, thank you so much, Prof. We have actually highlighted this in the guidance note for the session of information officer, that you cannot outsource the function of information officer, for example, to a company or somebody outside the organization. And this is mainly because the accountability remains with the head of the institution, and you can only authorize, if you're a juristic person, somebody else within that organization to be an information officer. But that function cannot be outsourced at all. And even the deputy information officer, it has to be an employee. And this you can find if you go to section 17 of POPIA. It actually indicates that you designate a person having taken into consideration the legislative requirement that regulate a labor employment. So that actually tells you that the legislature requires an employee to be a deputy information officer. So those cannot be outsourced at all. Thanks.
Thank you, Mr. Nemasisi. I see here there was a question by Anonymous, but it was quite early in the workshop. I signed on specifically on this workshop to hear about prior authorization, codes of conduct, and information officers, yet we are hearing another POPIA overview. I'm paragraphing what you've said, by the way, Anonymous. You signed on to receive guidance. I respectfully would like to say, Anonymous, I think we are dealing with the prior authorization questions. We are also dealing with the aspects relating to registration of information officers, and you are more than welcome, Anonymous, to ask any question relating to the codes of conduct. During the course of the session, we still have a bit of time. Then we have a question here by Maureen Knight. Is there a checklist or an example of what is required to simply become compliant? I think I'm going to ask to answer that one. There is no checklist. However, we do have what we call the 8 conditions, right? And it may sound now that it's another POPIA overview, but the 8 conditions for lawful processing, those are the foundation for processing personal information lawfully. So in order to be compliant, you should process, first of all, within those boundaries of the 8 lawful conditions. Then there may be other categories like special personal information. And as we've now also heard, there are other categories that in terms of 57 read with 58 may require prior authorization. Right. Now, there is a question here from Bianca Skippers. If a company fails to register the information officer before the deadline, what will the implications be due to the technical errors from the side of the information regulator? In other words, what Bianca is asking, considering the fact that there are technical glitches on the regulator's website, would this be a reason to condone not having registered by the 1st of July? Can I get one of the colleagues to answer that one?
I'll take it.
Thank you, Ms.
I don't
Solange.
think they can, we can't hold people accountable when our systems are unable to deal with the applications that are coming through. Thanks.
Right, okay. Then we have another question here. I see it really relates to the system. It says, while the system for registration of information officers, but that's the same question. Ms. Solal, I see here, this one is specifically addressed to you. Ms. Solal, when you respond to the question on registering one IO for multiple responsible parties, please also address, number 1, when we can expect guidance from the regulator in respect of that, as we have a guidance, a deadline, my apology, of the 30th of June 2021, and will the regulator be granting an exemption? Also, we cannot register deputy information officers without registering IO. That is a question from Dironcho Mohale.
Thank you for the question. I think I've tried in piecemeal forms to answer that in various other responses, but basically all of these issues have been put together and they've been escalated to the IT team. And as soon as they have been resolved, the regulator is going to publish a notice on our social media platforms and on our website regarding the status of the portal. And we're fully aware of all the multiple concerns that people have been experiencing while trying to register information officers. Thank you for that.
Thank you, Ms. Sola. We have another question here by Mike Owens. I assume he's trying to say, can the advocate please explain, yes, what is meant by exclusion under Section 6 of the Act? And must we adhere to FIC, in other words, Financial Intelligence, and the Disaster Management Act, as we are in the gambling industry? Okay, the question is a little bit confusing, but to the extent of Section 6 and Section 7, I think, Advocate Whippant, can you answer that question? I think Advocate Whippant is not connected right now. I think in terms of Section 6, and I'll take the question then. Obviously, in terms of Section 6, there are certain exclusions. Information that is purely for a household purpose, information that is, de-identified. In other words, this is not information that is no more identifiable. Remember, we said in terms of Section 1, personal information relates to an identifiable living natural person. So if it's de-identified, number 2, if it's a purely household transaction, and as you've correctly pointed out there, in the interest of national security, for instance, during the COVID situation, there has been COVID legislation that didn't necessarily exclude the POPIA, but there was certain compliance that had to happen in terms of that. Then you also have, Section 6 talks about law enforcement in trying to investigate serious criminal offenses, as well as, like you mentioned, the Financial Intelligence Center. These are people that have to process personal information and would be covered by 6, as well as the state president and his cabinet, as well as a provincial council together with a provincial head. Right. So going to the next question here, I didn't want to go into the exceptions of Section 7. Hopefully someone else will ask about Section 7. Okay, we have a question here from Juan Carlos Vargas. Good day, Information Regulator panelists. I would like to contribute the following question. What procedure has established the Information Regulator to amend mistakes, e.g. wrong emails on the Information Officer and Deputy Information Officer registration? Okay, that's a bit of a technical question regarding the website. I don't know if anyone wants to answer that. In the meantime, I'm going to look at other questions. I see Ms. Solal's camera is on.
Hi, yeah, thank you. This is part of the second phase of the portal, where we're dealing with amendments and how to rectify any incorrect information.
Thank you. Thank you, Ms. Solal, on that one. We have a question here by Charlene. Charlene says, good morning. If our group of companies plans to enter into binding corporate rules, okay, so I'm smelling Section 72, is it still necessary for all the companies to all enter into separate data processing agreements with each other, or would the binding corporate rules be sufficient? Actually quite interesting, because if we look specifically at Section 20, right? In other words, now I initially thought you were going to ask about transborder, hence I mentioned Section 72. But when looking now at this particular question, there is a legal obligation in terms of Sections 20 and 21 read together, that any responsible party that processes personal information, or together with its operator, must have written agreements pertaining to the safety and security and the confidentiality pertaining to that personal information. So to the extent of adequacy, I'm not quite sure if I can answer that, because the question hasn't given enough information. Then we have anonymous. I see there's a lot of anonymous people. In the context of group of companies, where a data subject has a contract with one legal entity in the group, can that data subject be considered as being regarded as a data subject or customer of the group of companies, since the companies all have the same branding and operate for the same purpose? I'm tempted to answer this Section 69 question myself, but I was hoping maybe one of the other panelists would be willing to deal with Section 69, in particular the provisions pertaining to direct marketing. Ms. Solal?
I think I'll just I think you're going to have to secure consent if you're looking at section 69(1). So, and I think I've also replied to that question on the chat. I'm not sure. It was a 3-pronged question. And I did state that you're going to have to secure consent in that regard.
Yes, it looks like it was a similar question to that again. But thank you very much, Mr. Lal, for assisting with that. Right. Dironcho Mohale. Advocate mentions that POPIA has no extraterritorial application. However, please advise Section 3B, Roman 2. I don't have POPIA in front of me, but I think you're talking about that section that talks about the application of the POPIA in the instance where there is processing of personal information, even by a foreign company using the infrastructure in South Africa. So in essence, that is that. Look, we, in our POPIA, and people must get this very, very straight from the beginning. The POPIA is not a mirror of the GDPR, nor is it a mirror of Convention 108 plus. However, right, as much as we don't have this extraterritorial application in the GDPR that explicitly talks about processing of personal information of EU citizens, right, it is, however, clear that if there is a link to the Republic in terms of processing of the personal information, then the South African Information Regulator would have jurisdiction to deal with anything related to that. Then we have a question here from Mdeni Ndwandwe. I hope I pronounced the name correctly, Mdeni. What is the regulator's view on the extent of the responsible party's duty, open bracket, intermediaries and the insurance company, close bracket, to ensure compliance by third-party sub-processors, such as, and I don't want to mention the name of the insurance company, I don't think that's fair, is reference to their website sufficient? So I think, once again, this is the whole situation of the data subject, the responsible party, and the operator. So, you know, the data subject gives his personal information to the responsible party. The responsible party is accountable to the data subject. The responsible party, however, in fulfilling its mandate to the data subject, requires an operator. And then in terms of 20 and 21 read together, there are certain obligations in terms of written contracts that must be signed by both the parties, confirming that the operator will respect the personal information, in particular, keep it as safe and secure as per the responsibility of the responsible party. Hi, here is Sanelisi. Thank you for the webinar. Will there be any guidance on what falls outside the ambit of the responsible party's legitimate interests in the context of processing of personal information? Is there anyone who wants to grab this one?
I think I'll just have a shot at it. I think it's one of those matters that we have to develop a guidance note on, legitimate interest. I think we've already done some work in that regard, and it will be forthcoming.
Okay. Mr. Lal, your voice is, I think your audio, it's kind of unstable. Can you say that again?
Sorry, Chair.
Sorry.
Hi, Ms. Sula. Chair's just asked you to kindly repeat what you said.
Sure. I said some work has been done in this regard already, and there will be something forthcoming on legitimate interest. Thanks.
Thank you very much, Ms. Sula. Then going back to the Facebook questions, we have a question here from Luyanda Alex Mahiman. I hope it's correct. If we have one IO for two entities, in the meantime, can we add the DIO, in other words, the Deputy Information Officer, as the IO for the second entity, And what are the implications in amending that in the near future? I know we've had several answers. Ms. Solal has also answered regarding phase 2. Mr. Nemasisi, do you want to give this a bite?
I think maybe firstly is to address the issue of appointment of, sorry, not appointment, designation of deputy information officer and delegation of certain power to a deputy information officer. With regard to the designation of deputy information officer, that's not compulsory. It depends on the operation of the organization. So if you are a big corporation, you find that the CEO, who is the information officer, is quite busy. It's advisable for that organization to consider designating one or more deputy information officers. I'll give an example of a private company, big corporation like Coca-Cola, for example. Sorry to give an example of that nature. But it's a big corporation that may have so many employees. The CEO of that company found that he will hardly be in the office. But as the regulator, we expect that when a request for access to information or a request for any access to personal information, it must be processed as soon as possible. Then that's where your requirement, because in order for the information officer to ensure that he or she doesn't fail to comply with its requirement in terms of POPIA and POPIA, they have to consider appointing a deputy information officer. Designating a deputy information officer, it's intended to assist that information officer in processing any request that may be brought to that organization, because there's a severe consequences for non-compliance. So it is in the interest of the organization and the information officer to actually consider appointing a deputy information officer, but it is not compulsory to do so. It's a discretion of the information officer that you need somebody to assist you in performing your obligation. Prof, now that maybe I've got platform, should I abuse my platform and address one aspect of the POPIA manual? I see question keeps on coming about the POPIA manual and exemption. We, as the regulator, the current exemption is coming to an end, if I'm not mistaken, is the end of June, in the next 2 weeks. We have requested the Minister of Justice to extend the current, I think Member Tilly touched on that, to extend the validity, the current exemption of from other certain private body to compile a POPIA manual. We requested a 6-month extension up to the end of December 2021. In other words, the intention there is that come the 1st of January going forward, everybody will have to compile a POPIA manual. That was the intention that we have. So the current POPIA exemption will be, we requested the minister, we're waiting for the minister to issue the gazette to confirm the extension for the next 6 months. But from the 1st of January, we expect every private bodies to compile the POPIA manual. Thanks.
Thank you, Mr. Namasisi. I see here is a repeat question that we get always from these webinars. It is a question from Tom Tandayo. Tom Tandayo, all right. If there is a data breach, how long should the responsible party take to report to the regulator? The Act says the breach should be reported, but not specific time. It actually is specific. It says within a reasonable time. Now, obviously, what is not reasonable to me may not be reasonable to you, but in essence, I think the guidance that one can give is that as soon as reasonably possible, in other words, as soon as reasonably possible that you have detected this breach, please notify the data subject and the Office of the Information Regulator. And the section goes further. It actually says the only instance when you may delay the reporting either to the regulator or to the data subject is if law enforcement requires this investigation to be on the hush. In other words, where you have a cyber criminal that they're either trying to entrap or they're trying to trace his whereabouts without raising the whistle, under those circumstances, you would be allowed to delay. But like I said, it's what is reasonable to me may not be reasonable to you. Right. Then we have another question here from the WhatsApp group. Sorry, the Facebook group. I keep forgetting that they are also here. There's a question from Vimbal Chikukwa. Is the head of an organization open bracket, the default information officer, close bracket, who authorizes an information officer, I assume what you mean in his place, who would be accountable in terms of that. I think Mr. Namasisi, our guideline speaks to that. If you could maybe give Mr. Chikupa an answer to that.
In the guide, look, if once you have designated, for example, certain powers or delegated to a deputy information officer, the information officer remains accountable. But then if you then authorize somebody as an information officer, I think that's where I'm not sure if we've covered this in the guidance note. Maybe I'll ask Prof. Advocate Weapon to advise on that aspect as to the issue of accountability in respect of situation wherein we have authorized somebody else as an information officer. But I am aware that in respect of designation or delegation of power to a deputy information officer, the information officer remains accountable in that regard. Thanks.
Okay, thank you very much. I think now, in us looking at all of the questions in the Q&A, when I see here in the chat box, we have other questions as well. So I'm going to try and address those. We have a question here from Asanda M. Kindly clarify the development of code of conduct, application for development of one's own code, and will an institution be deemed compliant if they're not ready by the 1st of July? Ms. Solal, may I ask you to kindly address this question regarding the codes of conduct?
Certainly. You know, it's not, I mean, there were a few questions about whether or not you have to develop a code of conduct. Section 63, I think it is, or 13, you may develop a code. So it's section 63. A code of conduct may apply in relation to the certain categories that are stipulated in the Act. So it's not compulsory for you to develop a code of conduct. And if there are certain processing activities that require prior authorization, then you would apply for prior authorization. And if your code of conduct is going to address those processing activities, then you don't need to apply for prior authorization in that regard. So to a large extent, a code of conduct is a self-regulatory or a self-accountability tool. It's not compulsory for you to develop a code of conduct. It would depend on the needs of that sector.
Thank you very much. Okay. We have further questions here as well. Many organizations have PIA manuals up on their website. If the information officer is not identified in the PIA manual, is it by default the CEO? Well, I think I can answer that for you, or Mr. Namasisi. Let me not steal your thunder. You can answer that.
It's fine. I wanted to say the Act prescribed the requirement that how the manual should be compiled. And if you do not identify your information officer in the manual, then that manual is non-compliant with the requirement of the Act. And therefore, you have to ensure that your PIA manual contain all the information as prescribed in the Act. The information of the contact details of the information officer and that of the deputy information officer, if they have designated deputy information officer, must be in the manual, because the purpose of that manual is to enable the people who may want to request access to the information of that particular body to be able to know who to contact and how to contact them. So if that information is not there, that manual is not compliant. And from the 30th of June, when we take over the PIA function, and 1st of July, when our enforcement power, we exercise our enforcement power as the regulator, we will obviously, our compliance unit will be taking action against those who may not be compliant. Thanks.
Thank you, Mr. Namasisi. I was talking with the mic off. Sorry for that. Right. We have further questions here. Maybe just to address one or two complaints you know, in a webinar of this nature, we have more than close to 400 attendees, and there's a lot of questions and answers coming in. As we select the questions, we try and not duplicate them. In no way are we not answering any of the questions that have been asked here. What we usually do at the end of this, we try and collate all the questions, and then the regulator will sit down and analyze these questions and try to communicate in a mass form some of the issues that were addressed here, maybe not just once or twice, but many a times. So please rest assured, whatever questions that have been asked here are not going to be tossed out. We are going to collect all these questions, and we're going to try and address them in an alternative method. Right, then we have a question here by Mohammed Musa. Please define the definition of credit reporting as per the guidance note on prior authorization. If an entity does not create credit reports, but places reliance on such credit reports to determine a data subject's credit worthiness for credit granting purposes, would one require prior authorization? That's a nice, interesting one. Colleagues, who wants to grab this one? Mr. Namasisi?
Thanks, Prof. We have clarified this in the guidance note by providing a guidance as to what is the credit reporting mean. So if, for example, you are not creating a credit, remember the credit reporting includes whatever information that you collect at the end for it to be required to be considered as a credit reporting, you must develop a report. And the credit industry, like for example, the banks do not create a report when they collect information. It's the credit bureau that creates a report. So the credit reporting is actually the credit bureau. Those are the people who create a report, which the banks use that report for them to process applications. So the people who are supposed to apply for credit for prior authorization insofar as the creation of the report, credit reporting, it's actually the credit bureau. They are the one who collect our information. Based on our collection of our information, our payment profile, they then create a report, which that report is the one that gets used by the banks or financial institution. So the prior authorization is only applicable insofar as the credit reporting is concerned by the credit bureau. Thanks.
Thank you, Mr. Namasisi. There's an interesting question here by Viseka. Good afternoon. What happens if my company does not have a website? Will they be non-compliant if they keep all their documents internally and provide same on request? I think there's a big misnomer that the POPIA only regulates personal information that is in the digital space. Any personal information, be it in the bricks and mortar world, your hard copy documents, right? All of that would fall within the realm of personal information. Then we have a question here regarding consent. I know our chairperson is very passionate about consent. Please advise whether it is true that we need to get consent from the people for posting a picture of them after having taken the same. There's a post that is circulating that it will become illegal to do so. I've actually seen that post myself, by posting someone else's picture without their consent. I think if Chair can just unpack consent and just answer Ndeni Ndandwe. Over to you, Chairperson.
Yes, consent in terms of POPIA means consent has to be specific. It has to be, I'm just looking at, it has to be voluntary, it has to be specific, and it has to be informed. So I think what should happen when we enter conferences or like this, like with this, you saw when this webinar started, there was a notice to say this webinar will be recorded. I think there'll have to be a paradigm shift in the way that we are doing things. Before we just take people's photos, we have to get their consent. to say, can you consent to me taking this photo? And if I take it, do you consent to us publishing it? Because in conferences, people take our photos and then our photos are all over the place without our consent being obtained. So that has to change. Thank you.
Thank you, Chair. Whilst I have you on this one, Chair, here's another one that I know you're very passionate about. Section 3(2)(b) of the POPIA provides that if any other legislation provides for conditions for lawful processing that are more extensive than those set out in Chapter 3, in other words, the 8 conditions for lawful processing, which law will prevail? Thank you, Chair.
There's a similar question on the chat with which I have responded. The one that takes precedence or primacy is the one that provides more extensive protection. So that if there is a piece of legislation that provides more extensive protection of personal information than POPIA, that piece of legislation will take precedence over POPIA to the extent that it provides more protection. The question that arose from that, or that arises, which I saw on the chat, is who makes that determination? Who determines which legislation takes primacy and over the other? And I said it is the information regulator which makes that determination. Thank you, Professor.
Thank you, Chair. I see here a question from Mike Burns, very interesting one, concerning whether or not a picture that has been taken for journalistic purposes, whether that would be included or excluded within the definition of POPIA. Obviously, this would now fall within the realms of Section 7. And I see Ms. Tilly will come and give us an explanation of Section 7. Over to you, Ms. Tilly. Ms. Tilly, your mic.
You're ahead of me, Prof. Small, and having your mic on, and in terms of identifying Section 7. I mean, one of the things that we have to remember with POPI is that there is also an exclusion in POPI which relates to journalistic, literary, or artistic purposes. So the Act doesn't apply, and then the Act says specifically to the processing of personal information solely for the purpose of journalistic, literary, or artistic expression, to the extent that such an exclusion is necessary to reconcile, as a matter of public interest, the right to privacy with the right to freedom of expression. I think one of the areas that this has come up recently during a number of protests have been the question of whether police can take photographs of the protesters and whether protesters can take photographs of the police. And in the circumstances, given that exemption, the answer seems to be generally yes. But I would have to say, with all of these things, this is an Act, certainly POPI to some extent has been tested, but this Act literally hasn't been in full operation. We don't have jurisprudence on it. We don't have a line of decisions. So we are going to learn from each other and from the courts as to where the exact limits on these things are. It doesn't mean we don't have views, but it's a very interesting exemption, and I think will be the subject of some debate.
Maybe just to add on that, Ms. Tilly, I think the information regulator has been in contact with the Press Council to discuss the issue of a code for the press, as envisaged by Section 7. I mean, you mentioned to us the balancing of the interests, the right to privacy, the right to freedom of expression, as well as the right of the journalist to obviously publish the story. But there is also this issue of the code, and we can just assure the public that the regulator and the Press Council have been in contact pertaining to this matter. Whilst I still have you on here, Ms. Tilly, if you don't mind, there's a question here.
Professor, sorry, I'm sorry to interrupt you. I have had a message that we have to get off this webinar before 12:30.
Oh, all right.
So we need to just wrap up, maybe. And
Okay.
maybe after this, Nomzamo will announce how we're going to deal with the questions that have not been answered. Thank you. Sorry for interrupting.
Thank you, Chair. Okay, so the last question I'm going to ask to Ms. Tilly. People are sending unsolicited messages to get them to participate in their networking seminars and so forth. Kindly explain the position regarding that. The microphone again, Ms. Tilly.
Thank you, Prof. I think the difficulty is that this is a business model that has existed for a long time. And in any business model that has existed for a long time, what has become practice may appear, normal and completely okay. Well, I think things are shifting with the introduction of this legislation. One of the points of this legislation is to make sure that your personal information is only processed when you want it to be, when you agree to it being, when there's some really good reason for it being. And my personal information being processed without my consent for a purpose that I don't know about, for something that may advantage me, but may not advantage me, may be of no interest to me, is no longer a good business model. It's just not. That's where we are. So I think that can be frustrating because your business model can literally, we know data is the new oil. That's why it's we're all interested in it. Well, some of us for other reasons, but it's a very important part of doing business in the 21st century. And that's one of the reasons why it's being regulated, because it is a very important part of doing business. And you have to do it in such a way that you're not violating people's rights. That's just how that is. The right to privacy is real, and the regulator is here to step up and protect it.
Thank you very much, Ms. Tilly.
Sorry, Prof.
Oh, yes. Advocate, I just want to remind the chairperson did say we need to wrap up, but I'm not going to curtail you. Please proceed.
Oh, thank you, Prof. Prof, just apologies to everyone. I think there was something wrong with my functionality. Prof, just to let you on the question that Mr. Namasisi referred to me concerning an acting information officer who's authorized. The accountability still remains with the actual information officer, because that person is actually the person who has been appointed for that specific role and who is recognized in terms of the provisions of POPIA and POPIA. But what is also very important, Prof, concerning the other question that was asked about the reasonable time to report a data breach, there are two distinctions that we need to take into account. If a data breach occurred at the level of an operator who operates on behalf of a responsible party, then the data breach must be reported by the operator to the responsible party with immediate effect. But the responsible party, when they have that specific data breach that has come to their knowledge, must then report it within a reasonable time. The GDPR makes provision for 72 hours, but the reasonable time, as Prof has alluded to, is basically just been given as a word, but there's no specific pointed time to say 2 or 3 or 4 days. So that's currently the position in our law. Thank you, Prof. Over to you.
Thank you. And that wraps up our Q&A session. I just want to thank our distinguished panel, starting with Advocate Tlakula, our chairperson, Ms. Alison Tilly, Advocate Weepend, as well as Ms. Solal and Mr. Nemasisi, as well as the professionalism of Ms. Zondi in organizing this event. And because of shortness of time, I'm going to give back over to Ms. Zondi. And then I don't know if someone else will give a vote of thanks. Thank you, Ms. Zondi.
Thank you, Prof. Thank you for that wonderful job that you've done. After I've made the announcement, I'll give back to the chair to just close the session. Thank you very much. I just want to share that the questions that we may have not been able to answer on the webinar, we will create a product that has question and answers from this webinar, and we will share it through our stakeholder database as per your registrations, but we'll also share snippets of the Q&As on our social media, but we'll also make some of the answers to the questions posed that we may have not been able to cover on our website as well, attached to the recording of today's session. So thank you very much. We will definitely ensure that we respond to as much question as we can. But thank you, Prof. You covered most of them from even our Facebook channel. And I would just like to also thank the panel members who have been responding on the chat group as well. It assisted greatly. So thank you so much. Chair, I'll hand back to you. Thank you.
Yeah, thank you very much, and thanks. Let me also add my voice to thanking all my colleagues for the wonderful job that you have done, and thank the presenters also, the presenters, Advocate Wepond and Ms. Tilly, Professor Snail for how you handled the Q&A, and my colleagues, the executives, Mr. Lal, Mr. Namasisi, and all the participants. This is a journey, as I have said, and it's going to be bumpy, but we're going to be holding each other's hands as we embark on this journey. This POPIA, I want to assure everybody that this act does not prevent people from continuing with their business. Please continue with your business, your obligations, as you have always done. Please continue with your innovation as well, because POPIA does not stifle innovation. The only thing that we have to do is to ensure that when we process personal information, we do it in accordance with the Act. If we can't do that, please, we should not collect personal information. Thank you very much, and goodbye to everyone, and thanks for joining. The webinar ends here. Thank you.